Good morning, this is your Kelso Report for Wednesday, September 12th, and I'm your host, Clark Kelso. Our topics today include an abortion decision striking down an Idaho law, an administrative law case involving the appealability of an agency decision, a case involving the issue of whether multiple uses of a taser constitutes excessive use of force, and a case involving a bank misrepresentation that led to a wrongful foreclosure on a mortgage. Well, we begin with the Ninth Circuit in McCormack v. Heidemann, which is an interesting abortion decision involving Idaho law. Now, it turns out that there are really no providers in southern Idaho who do abortions. The nearest provider is apparently in Salt Lake City. The plaintiff in the case was a woman who consulted with a physician over the internet and was prescribed an FDA-approved medication used to induce an abortion. Well, a county prosecutor filed criminal charges against the woman for undergoing an abortion in a manner not authorized by statute. In particular, Idaho statutes require that an abortion be conducted by a licensed physician and that the procedure be conducted under certain defined circumstances. A state district court dismissed the criminal complaint without prejudice, and the woman then brought suit in federal court seeking to enjoin enforcement of the Idaho statutes. The federal district court granted a preliminary injunction, and the issue before the Ninth Circuit was whether the plaintiff was likely to succeed on her claim that the relevant statutes were unconstitutional. Applying the undue burden test from Planned Parenthood v. Casey, the Ninth Circuit affirmed the district court's issuance of a preliminary injunction. The court concluded that the statutes were an undue burden because, as drafted, the statutes in effect require women seeking abortions to police their provider's compliance with Idaho's regulations regarding how abortions should be performed. So, if the provider fails to follow Idaho law, the woman may be criminally prosecuted. For example, if a woman terminates her pregnancy during the first trimester, but fails to ask the physician whether the office has made satisfactory arrangements with one or more acute care hospitals within reasonable proximity thereof, well, the woman would be subject to a felony charge if the physician has not made such arrangements. As applied to the facts before the court, if a woman elects to take physician-prescribed pills obtained over the internet to end her pregnancy, which is not authorized by statute, well, she is subject to felony charges. The court held that requiring women to explore the intricacies of state abortion statutes to ensure that they and their provider act within the Idaho abortion statute framework results in an undue burden on a woman seeking an abortion of a non-viable fetus. The court affirmed the preliminary injunction. Next, administrative law. One of the big principles in administrative law is that final agency decisions should generally be judicially reviewable. Of course, there are limits to this principle since many decisions are made along the way to reaching a final agency decision, and we don't want all of those decisions to be subject to review. A good example is found in Palomar Medical Center v. Sebelius, which involved the operation of a recovery audit contractor program Congress established to help reduce Medicare costs. Medicare pays only for those services that are medically reasonable and necessary. But to keep the program going, Medicare providers are frequently paid in full for certain of their services, subject to a subsequent audit. Under the Recovery Audit Contractor Program, a paid claim can be reopened and then audited to determine whether the services were medically reasonable and necessary. According to the Secretary's regulations, there must generally be good cause to reopen claims paid within the preceding 4 years. But other regulations declare that the decision of whether to reopen is not subject to appeal and is final. In Palomar Medical Center, an audit of reopened claims came out against the hospital, and it wanted to argue before the district court that there was no good cause for even reopening those claims. Palomar argued that absent the ability to challenge the good cause finding in court, there would be no judicial review whatsoever of the decision to reopen a claim, notwithstanding the regulation that requires good cause. The Ninth Circuit rejected Palomar's argument, focusing its attention on the other regulations that made the decision to reopen non-appealable and final. According to the Ninth Circuit, Congress would not have wanted the audit program to get tied up on questions of whether a claim should have been reopened. That's a preliminary question. The merits of whether the claim was for medically reasonable and necessary services, that's the key to the success of the audit program, not the collateral question and preliminary question of whether a claim should be reopened. For the Ninth Circuit, the Secretary herself had adequate power to determine whether the good faith standard was actually being observed, and the Secretary could implement corrective measures as necessary. You didn't need judicial review. Next, a Fourth Amendment case involving tasers. A police officer is legally justified, of course, in using reasonable force to detain and arrest someone suspected of a crime. But as with all powers, there are limits, and a police officer who uses constitutionally excessive force can be subject to liability as well as his or her department. The issue before the Ninth Circuit in Marquez v. City of Phoenix was whether a police officer had used constitutionally excessive force by repeatedly deploying a taser against a combative suspect, and whether the manufacturer of that device had provided sufficient warning that its repeated use may lead to death. The suspect in the case died from the repeated use of the taser. The warning issue was the easiest, since the manufacturer provided clear warnings that a taser could result in serious injury, including death. As for the excessive force claim, the evidence was that the suspect received 9 5-second cycles from the device, 2 while it was ineffectively deployed in probe mode, and 7 when it was deployed in drive stun mode. He was also wrestled into submission by 2 policemen. Although this was a close case and there is a dissent, the majority concluded that the relevant factors favored a finding that the use of force was reasonable. Once the police officers crossed into the plaintiff's room, they were greeted by a blood-spattered room, an injured adult, and a child in evident distress. This alone was cause to believe that at least one serious crime had already been committed. The suspect was warned that he would be tased if he did not comply, yet he actively resisted arrest. And so long as he appeared to be actively resisting, the officers were justified in continuing to use the taser to attempt to restrain him. Finally, we have a case involving bank fraud and an unlawful foreclosure that resulted from it. It's a case that's, or rather an example of an allegation that we've seen in literally thousands of lawsuits in the last 3 or 4 years involving alleged bank and foreclosure fraud. Many of these cases end up as losers when it turns out that the plaintiff's allegations can't be proven. But in Ragland v. U.S. Bank National Association, the 4th District dealt with a case where the plaintiff's misrepresentation allegations were supported by evidence. In particular, the plaintiff produced evidence creating triable issues of fact as to whether the bank induced her to miss a loan payment, thereby wrongfully placing her loan in foreclosure, and whether she suffered damage as a result. She was seeking simply to negotiate a loan modification, but the evidence indicated she was told by a bank official to deliberately miss a payment to trigger the loan modification process. However, when she missed the payment, that triggered a hostile reaction by the bank that ultimately led to foreclosure of her home. The Superior Court had granted summary judgment to the bank, but the 4th District reversed and sent the case back to the Superior Court for further proceedings. And now is about the time the bank should be settling this case. Seems like a winner for the plaintiff. And that's it for today's Kelso Report. Have a great day in the law.